Plaintiff's first amended complaint opposition to defendants' demurrers. Action filed, May 1st, 2013. First amended complaint, June 14, 2013. Defendants. Learn Yuan Liu, Penny Tan. Office of Cal, State Treasurer, Bill Lockyer, Mark Paxson. San Bernardino County, Michael Ramos, Gerard S. Brown, Bernice Rodriguez, DDAS Mitchell, Ditto. Rod Hoops, David Freya, Robert Brender, Josie Brender. UNKMWN Special Federal Prosecutor, IRS. Deputy Des 1-20. AMDJ Realty, Diana Luo, Andy Luo. Contact 1 Realty, Carlos Granados. San Bernardino Tax Collector, Larry Walker, Jice Johnson, Virginia Conixer, Jill Langley, Bailiff J. Holden, Raymond Hilfer, Julie Francis, Nurse Hancock, Amber Anderson, Vince Welch. People's Republic of China and all persons unknown, claiming any legal or equitable right, title, estate, lien, or interest in the property described in the complaint adverse to plaintiff's title, or any cloud on plaintiff's title thereto, and does 1-20. Defendants. Complaint to quiet title. Complaint for damages. Breach of contract. Money hidden received. Fraud, unfair business practices. Gross negligence. Defamation, libel, slander. Invasion of privacy, 4th Amendment. Intentional infliction, emotional distress. Breach of trust to the oath. Aggravated malice assault. Wife. Cabin. Kidnapping. UN lien, naval and civil rights. Violation USC 18. CH. 13-241-242. Violations of First and Religion. Complaint of international law and treaty violations. I. United Nations Declaration on Rights of Indigenous Peoples. Christian calendar. July 10, 2013 AD. Nourish calendar. First day of Ramadan in the year of 1433 MC. Islamic calendar. Ano IXC Sun in 19 degrees Cancer. Moon in 21 degrees Leo. Ano IXC in 19 degrees. In 21 degrees. Peace, tolerance, truth. Salutation on all points of the triangle. Respect to the order. To all whom it may concern, greeting and help. Added. Do what thou wilt shall be the whole of the law. Opposition to demurrer. In Hames v. Kerner, the court held that judges should liberally construe per se pleadings. It further stated that allegations such as those asserted by the pro se petitioner, however inartfully pleaded, are sufficient to call for the opportunity to offer supporting evidence. We cannot say with assurance that under the allegations of the per se complaint, which we hold to less stringent standards than formal pleadings drafted by lawyers, it appears beyond doubt that the plaintiff can prove no set of facts in support of his claim which would entitle him to relief. Comment. Illiberal construction of pro se pleadings. University of Pennsylvania Law Review, Volume 159, 585. As to substantive matters, however, the knowledge differential is precisely the reason for affording per se litigants special deference at the pleading stage of litigation. Similarly, a mistaken or incomplete understanding of the law can result in the per se litigant pleading the wrong cause of action or, alternatively, not pleading an available one. 63. Furthermore, individuals choosing to proceed per se because they cannot afford legal counsel will often lack the resources to uncover facts prior to filing their complaints. 64. Consequently, these complaints will frequently be thin on details and therefore require that courts draw more inferences in evaluating motions to dismiss. See Julie M. Bradlow, Procedural Due Process Rights of Per se Civil Litigants, 55 Uchi, L. Reverend 659, 678, 1988, noting that flexible construction of per se pleadings is meant to combat dismissal where a cause of action exists but the complaint fails to say the magic words. As a result, pro se litigants will understand the allegations requiring additional factual enhancement to make the necessary, but unmade, inferences plausible and limit court skepticism. Indeed, including suggestions in the opinion as to the types of support needed to sustain missing elements would be advisable, as per se litigants may otherwise neglect to include all the facts within their possession on the assumption that complaints should be as short and plain as possible. 224. For a compelling discussion of why cause of action information should not generate concerns over judicial partiality, see Jonah Goldschmidt, Judicial Assistance to Self-Represented Litigants, Lessons from a Canadian Experience, 17 Midge, St. J International L 601, 622-23, 2009. To go one step further, discussing the type of factual support tending to adequately show motive in the relevant context would at least place him on a more level playing field with litigants whose lawyers understand the type of support required to succeed. 226. For a similar suggestion that instructions to per se litigants be included in orders granting leave to amend so that they can correct defects in their complaints, see Ziegler and Herman, Super Note 64, at 211. Conclusion. Liberal construction developed in response to challenges facing per se litigants that courts identified as having the potential to unfairly deny them access to discovery. As the term itself suggests, those challenges consisted of the potential for 1. Incomprehensible or inartful drafting and 2. Incorrect or incomplete invocation of the legal bases for claims. But these difficulties do not include the potential for the standard for evaluating complaints to punish per se litigants reflects the background notice pleading regime under which the Supreme Court first granted the leniency. The Conley knows that of. Fact standard raised a deceptively low bar to pleading a cause of action adequately, thereby posing little threat of inherent unfairness to per se litigants. Through informal channels did lower courts heighten pleading requirements to make suits pursued by particular claimants, including per se litigants, more vulnerable to dismissal for a failure to state a claim. The unexpressed nature of this development perhaps excuses, or at least explains, the system's previous failure to re-evaluate liberal construction as an adequate accommodation to per se litigants. However, it will remove the disguise, ushering in a new era of heightened pleading requirements. Plausibility analysis sets yet another unique challenge to the set of concerns initially identified as requiring liberal construction of per se pleading since each of its prongs unfairly punishes unrepresented litigants. As a result, courts would be remiss not to allow greater leniency for self-represented litigants at the pleading stage of litigation. This comment endeavors to provide insight into exactly how the plausibility standard disproportionately undercuts the efforts of proselyticons to access discovery in order to highlight why, to particular supplements to liberal construction are advisable, without meaningful adaptations of the sort here proposed. Our legal system risks not only defying the long-standing statutory protections afforded to the right of self-representation, but also infringing upon proselyticons' constitutional right to a meaningful opportunity to be heard. Rory K. Schneider, University of Pennsylvania Law Review, Volume 159, J.D. Candidate, 2011. University of Pennsylvania Law School, B.A., 2008, The George Washington University. Complaint. Me Momi and Hume Assessor. Preliminary Statement. This is a suit for defamation, invasion of privacy, intentional infliction of emotional distress, complaint to quiet title and for damages, breach of contract, fraud, unfair business practices, negligence, gross negligence, torture, breach of trust, breach of oath, breach of duty, breach of fiduciary duties, aggravated malicious wanton assault, battery, kidnapping, wiretapping, treaty violations and human rights violations and international laws treaties herein alleged that the defendant, S, wrongfully intruded upon the plaintiff's land on May 5, 2012, and forcefully wrongfully evicted the plaintiff by threat of arrest in the Humane Society, taking the plaintiff comfort, creature best friend, and depriving the plaintiff of proper notice to gather all items belonging to him or sort out the dispute. On May 6, 2012, plaintiff called 911 to report trespassing violation of a realtor on plaintiff's property. Plaintiff was wrongfully arrested and charges were trumped up. That were cause for plaintiff's arrest were dismissed, i.e. burglary. Instead, now the plaintiff was subjected to a malicious prosecution and held in a cage and brought before a kangaroo court without subject matter jurisdiction where no corpus delicti was ever found, and despite all the overwhelming evidence, the plaintiff was innocent under duress. He signed a plea bargain under threat of a 90 psychiatric ward mental health evaluation for proclaiming his innocence. On May 18, 2013, the plaintiff was released early from jail despite the verbal agreement and promised to be released after court if he signed a plea bargain 4 times served. The plaintiff revoked his plea under penalty of perjury before a California notary on May 22, 2012, and appeared at the kangaroo court at or around 3:30 p.m. and was denied access to clerk by armed bug swearing and pretending to be peace officers. Subsequently, the plaintiff was assaulted and battered from the court, and 911 was contacted in the office of the governor of California regarding the allodial title and plea revocation. The plaintiff appeared at Rancho Cucamonga Court under duress to abide by terms of under duress court order probation review, at which point the plaintiff was assaulted out of the court before entering the metal detector again and slammed up against the glass. The plaintiff's mother cried out again, asking them to stop just as the day before, but ultimately the plaintiff was arrested by the armed thugs in front of a totally different court, but the men all wear uniforms identified as San Bernardino County Sheriffs. The defamed him and forced fingerprints and contract under duress and protest and released plaintiff from cage. Plaintiff waited from date of release May 25, 2012. On the 10th day, as stated within sworn affidavits, plaintiff assumed all charges were dismissed and re-entered possession of subject property on or around June 2, 2012. Suddenly on June 17, the plaintiff's home was surrounded by SBSD defendants. Again, they had assault rifles and helicopters and loudspeakers at 1130 p.m. Plaintiff called 911, whom said to just go out and explain the situation. When he did, he forced to ground with multiple laser lights with them 16 rifles. Then the armed thugs jumped into the plaintiff with his knee, forcing his face into the hard coal cement like a criminal in front of the entire neighborhood, and only responded, "Shut up, you're under arrest, asshole." How many other people are inside? When plaintiff asked why he was being detained and what the controversy was. Then with a complete lack of regard for safety and malicious willfulness, wanton disregard for human rights, he jerked the plaintiff off the floor, attempting to get the plaintiff to stand up and walk with him, but the plaintiff was unaware and unprepared and is disabled because of major shoulder cut, tear, and weakened ligaments and fracture caused by a debilitating shoulder injury. I am sure he didn't know, but it was really unnecessary and gross negligence to harm the way he jerked it, because ever since the plaintiff's shoulder has been so easily re-injured, and it constantly throbs now when used in any unrelenting manner. Most of the plaintiff's paperwork was removed from the house, and the plaintiff and 7 of his friends were charged with burglary. Furthermore, the plaintiff was then subjected to another malicious prosecution with only one other defendant, whom also happens to be an Irish American national. What a coincidence, huh? Well, the unknown federal prosecutor said, "Your Honor, you can't give Bernard, me, Ellen, or these men are sovereigns and do not believe in the jurisdiction of this state or even this very court." This statement alone proves beyond a doubt this is discrimination and human trafficking violations on all defendants who had any knowledge of the plaintiff's true status by any means, including implied, expressed, and expressed. In short, because this is only a brief description of an insanely complicated case, I am trying to just give an overview and basic idea of events. On July 5, 2012, after weeks of being denied fair hearing and being assaulted from court several times and so on, the kangaroo court released and dismissed all charges against both nationals. The plaintiff was offered to continue on probation. He informed the kangaroo court he revoked his plea and was arrested at probation check-in by crazy armed thugs for making loud noise or something ridiculous that was later dismissed as well. See how the SBSD defendants make it so crazy complicated and hard to even keep it straight, but stay with me, we are getting there. The kangaroo court pretended like it had no knowledge of the plea withdrawal posted outside the court door, and even to mock the plaintiff, the very same thug who removed him from the court and refused to accept service of the plea withdrawal on May 23, 2012. Deputy Collins never said a word about how he witnessed me attempt for more than 40 minutes to come into the court. Plaintiff's attire had a curse word on it, so Collins decided the plaintiff was a sovereign and physically assaulted and battered while the plaintiff's mom just screamed to stop. To wit, this is the true words found on a notarized affidavit of fact signed by plaintiff's mother begrudgingly once she was informed the plaintiff was facing a 15-year prison sentence before the SBC district attorney almost dismissed the obvious beatrice and fraud on the court, causing the plaintiff's girlfriend to deliver affidavit to plaintiff's mother, and this affidavit were given to plaintiff's supposed conflict panel defense attorney, who had already declared the plaintiff incompetent, despite knowledge of previous psychiatrist evaluations from recent court trials where similar situations transpired, because the plaintiff is informed and the so-called by the court psychologist nonconformist Christopher is not incompetent or mentally ill. He chooses courses of action deliberately, calculating, choosing to clash with law enforcement on the dates of the incidents and within the court officers and judge, believing God created him equal to any individual. See James authoritarians. This was information was known known to James Brown and Mario, Marcin S. and Gerard Brown because the plaintiff used a commonly unknown defense. State police power extends only to immediate threats to public safety, health, welfare, etc. Michigan v. Duke 266 U.S. 476 leg. At 449, which driving and speeding are not. California v. Farley said, RPT 89, 20 CA 3D 1032, 1971. The California Supreme Court in San Francisco and Riverside District judges who are found to be involved in denial of plaintiffs in custody emergency habeas corpus petitions will be added as defendants on a future amended complaint. Honorable Court's recognition of human beings having inalienable such as right to travel, peaceful quiet possession, life, liberty, property. The Chino Court maliciously assisted at every stage of the malicious malfeasance and misprision of the plaintiff. They tried to find him incompetent. This was obvious violation of the plaintiff's rights to speedy trial, so plaintiff's mother deliver this to James Brown. Even though I told Gerard Brown Deputy Collins assaulted me out and watched me for 30 plus minutes carefully taping all the motions for extension of time and motion to withdraw plea and motion to dismiss and affidavits of fact act. Literally thousands of documents were left outside the courthouse door on May 23, 2012, and my mom mailed the court in the jail and she mailed copies to the prosecutor too with proof of service by mail and third party. They knew I was innocent and every single one of the defendants played some role in the malicious prosecution either by supplying false statements or trumping up evidence for no reason. It was so silly. 11 days time served turned into a 2-year prison sentence because I refused to accept the ridiculous terms of probation and refused to recognize the court or judge's authority and demanded my mother as a witness and to read her affidavit to it. September 26, 2012. To Clerk of the Chino Court. Judge Gerard Brown. Deputy District Attorney Steve Mitchell. Defense Attorney James Brown. Re. Christopher Allier Fleming booking number 1,206,342,043. Case FCH 1,200,209. I, Muriel Fleming, mother of Christopher Fleming, do hereby state that I drove Christopher Fleming to the Chino Courthouse on Thursday, May 24, 2012. He had paperwork documentation that he was presenting to the court. It was approximately 4:10 p.m. and the courthouse had closed at 4 p.m. so the deputies on duty prevented Christopher from dropping off the documents inside. Christopher had paperwork to submit to revoke his plea and wanted to present these documents to the court. The following is a list of the document Chris had in hand. Judicial notice and proclamation and legal notice. Name declaration. Correction proclamation and publication. Allotio title and notice to revoke his plea. I witnessed the officer refusal to allow Christopher to post these papers on the courthouse walls outside as public notice. Christopher proceeded to tape these documents on the pole as public notice since the officers would not take his documents to put in his file. I swear under penalty of perjury that the foregoing is true and correct. Muriel Fleming. Muriel Fleming. State of California. County of Los Angeles. On September 28, 2012 before me. Sylvia at the Wheeler Notary Public personally appeared. Muriel Fleming. Who proved to me on the basis of satisfactory evidence to be the person whose name is subscribed to the within instrument and acknowledged to me that she executed the same in her their authorized capacity and that by her their signature on the instrument the person or the entity upon behalf of which the person acted executed the instrument. I certify under penalty of perjury under the laws of the state of California that the foregoing paragraph is true and correct. Witness my hand and optical seal COM at number 1,986,968 PCT4. Notary Public, California. Signature of Notary Public, Sylvia Aviquilla Micom EXP August 30th, 2016. One who operates outside of his jurisdiction out of his territory is not a gay with immunity, I said to the crook in the black robe on the bench. My argument in court in my habeas motion to the Chino Superior Court, Riverside District Court, and San Francisco Supreme Court on or around September 9, 2012 and also now on appeal and now here in this four corners of the original complaint filed on May 1, 2013 and his first amended complaint of July 13, 2013 is this simple. If Christopher Fleming was at the property May 7, 2012 and in possession, why did the defendants assault and defame, detain, injure and force him to leave begrudgingly in 5 minutes? Why didn't they arrest Christopher Fleming then and charge him with theft by false pretense? Defined in Black's Law Dictionary 3rd Pocket Edition as false pretenses. The only two convicted on May 17, 2012 for thief by false pretense. 532 of that would mean that I had used someone else's name or social security number, which is completely absurd and preposterous, especially after all the overwhelming evidence to prove that I was able to seemingly set off or discharge a $150 debt for Christopher Fleming not even 2 weeks prior, which was the only reason the realtors even talked to me in the first place. They asked 3 times for me to send pictures of the paperwork showing the bills I set off using trust. $619,070,146. Exemption as a creditor for bankruptcy and so forth. Plus it would mean didn't, and you knew that, but you didn't care. You just wanted to railroad me because you know a high school dropout genius cracked the code and figure what was going on with the infant and decedent estates being in deceased status, so the whole thing is in probate and the government can just run my trust. Well, sorry guys, you can't just find me guilty because I plead. You have to find a factual basis for the plea, and I am sitting there on the record yelling I never used a false name. This is fraud. Even the public defender Mario said all they had you on is trespassing. So let's recap. Plaintiff calls Treasury, appoints public servant as fiduciary. Trustee accepts and freeforms then breaches. Plaintiff notarized statement of Treasury breach is proof of funds of trust and credits to set off discharge debt to acquire real property in the form of uncivil international promissory note as consideration given to reality. Contact 1 and AMDJ Realty for your approval of offer. Debts accepted in promissory note, security instruments and security agreement. Escrow agreement is signed by plaintiff, given to realtors. Treasury calls realtors, claims it's fraudulent without any proof. Contact 1 refuses to make written request for initial escrow deposit as promised and agree to facilitate transfer. Plaintiff barred from acting or recouping instruments by contact 1 and Amgen Liu. Weeks past, plaintiff still in possession of abandoned property, cleaning work in peaceable possession, pedal possession, bona fide possession. Suddenly forced out by threats, pack your shit and get out in 5 minutes or you're going to jail. Plaintiff leaves, returns next day, serves Amgen realtors express notice of claim of right and adverse possession, lien and default of Liu. Armed guards arrest plaintiff because Amgen realtor claimed she owned or was interest in house and plaintiff trespassed. She signed citizen's arrest and never showed up to court and charges dropped. Plaintiff signed plea under duress, tried to revoke. Using notary as witness. Armed thugs refused access to court, arrested in front of mother and assaulted in front of his mother 2 days in a row at 2 different courts by 9 different thugs wearing guns and badges holding notices of the plaintiff's indigenous natural person. Status affidavits of fact notarized stating he is such. Maliciously prosecuted and offered to go home at least 11 different times. The plaintiff refused, so he may appeal and has in KC 058690 where the plaintiff's lawyer has shown the court the plaintiff with ineffective assistance of counsel at trial. Because the court report shows obvious violations of the plaintiff's basic human rights and constitutional protections. Furthermore, the plaintiff filed the action as soon as he was able to acquire as much information as possible. There is so much more that happened, and after discovery, if I can fix this, I promise it will be much more organized once I have all the facts and evidence that is still being held by the sheriffs, even though the case has been dismissed and I served an excessive 10-month sentence under false imprisonments and subjected to blatant violations of religious freedoms and discrimination, which is the overwhelming cause for this action because it caused me so much anger I was not able to practice my faith, and the jail refused me fundamental books and religious items that were not a threat to the facility or anything. They refused to send mail to the courts for me. They sexually assaulted me and searched my cell several times a week and literally threw my entire legal papers all over the cell just so I couldn't keep things straight. They disciplined me for refusing to work because of disability and religious holidays. Then I was falsely charged with assault on a deputy and without a fair hearing put in solitary confinement because they called me a problem inmate. I was not allowed any exercise phone visits, and legal materials were denied, so I couldn't file the appeal on time. Thank God for my lawyers helping me with the appeal so I may pursue this civil action. Regardless, I just feel like if I had notice I wouldn't have lost all my stuff if they gave me time to pack up and move out and return the instruments to Sonnet or said why they were not gonna honor the contract. Nothing, I was just supposed to guess. It's just really screwed up, and it's not how free societies operate. We have due process on this land. Not only was the plaintiff denied freedom from unreasonable searches and seizures of his person, houses, papers, and effects, but subjected to repeated torture, and grievances filed in the jail were laughed at or ignored. Plans filed with the state and county have all been denied, and I must enforce the de jure laws of this land and remind the armed thugs where they get their authority from. It's nothing personal, it's just business commerce. The defendants causing physical and emotional damages. In addition, defendants' conduct was so intentional and outrageous that the imposition of punitive damages is appropriate to punish the defendants for their actions and to deter the defendants from further reprehensible conduct and violations of the following laws, and also other rights and remedies contained within the original complaint or any grievance forms or claim forms. Demand letters and statements of damages. Plaintiff seeks relief under all said claims and by this complaint from every defendant known, currently unknown, has alleged participated or someone violated each and every one of the specifically stated codes or international treaties, laws, et. Do it. United Nations Universal Declaration of Human Rights 1948. Done at Pulay de Shayo, Paris, adopted and proclaimed by General Assembly Resolution 217A3 of December 10, 1940.